5 seconds to go. Start. It is submitted that therefore the raw materials naphtha and natural gas were required to be used by the eligible unit SR Steel Limited in the very same steel unit and for manufacture of the steel only. It is submitted that if the interpretation made by the High Court and the tribunal is accepted, in that case, even when the eligible unit does not itself utilizes the raw materials, it may, after availing the exemption, simply transmit the raw materials to any other unit or entity, even the said entities are not eligible to the exemption, and such entities, though are not eligible, would then get the benefit of exemption. It is submitted that that could not be the object and purpose of granting exemption to the eligible units only. It is submitted that while introducing the incentive scheme, the department issued the list of industries of eligible units and non-eligible units for any exemption from sale purchase tax on procurement of raw materials. It is submitted that in the present case, the power generating companies were specifically put in the non-eligible units category. It is submitted that in the present case, despite being fully aware of the clear and unambiguous terms and conditions of the notifications, wherein the power producing companies were specifically made ineligible for availing the exemption, and though ESL was required to use the raw materials, naphtha and natural gas in their own unit, after availing the exemption from payment of purchase tax, the ESL did not use the said raw materials in its unit, but sold the said raw materials to another company EPL, and EPL used the said raw materials, naphtha and natural gas for generating the electricity which came to be subsequently sold to the ESL. It is submitted that thus through such circuitous method the ESL passed on the benefit of exemption to EPL, which otherwise the EPL was not eligible and or entitled to. It is submitted that thus the interpretation advanced by the assessee ESL, accepted by the High Court and the tribunal, would completely defeat the purpose of exemption notifications and would be giving premium to such dishonest assessee dealer who, after availing the exemption, would sell the raw materials to another industry entity who as such are not entitled to and or eligible for such an exemption. It is submitted that if the interpretation advanced by the assessee is accepted, in that case it would permit industries which are eligible for exemption to simply purchase the raw materials, not use them for any manufacturing in their own units, and then simply transmit them for use and manufacture by other units, even though such units are not eligible for exemption under the notification policy. It is further submitted by Shri Maninder Singh, learned senior advocate appearing on behalf of the state, that in the present case the wordings used in the parent exemption notification and entry number 255-2 dated 5th March 1992 are very much clear and unambiguous. It specifically provides the conditions for availing the exemption, and the eligible units have to fulfill all the conditions stipulated in the parent entry number 255-2 dated 5th March 1992. Stop.